So it's a decision from the New Jersey Appellate Court that if you stick your face into a plate of hot fajitas, you do not have a lawsuit.
And then he panicked and knocked it all over.
Yeah, it sounds like it does sound just horrible, doesn't it?
To watch it.
Yeah, if there was a YouTube video of this poor guy, and I'm sure he did get burned, but if you, there is this idea about open and obvious danger. Professor Malaguti actually had a case at the appeals court on open and obvious danger as well. Guy dives into the shallow end of the pool and breaks his neck. And the court at the end of the day says, well, you dive into 4 feet of water, 3 feet of water, you should expect that you're going to get hurt. And same thing here. If you stick your, I mean, because a lot of times those platters do come. I mean, they're sizzling. They are in fact sizzling. Putting your head down is dangerous. And just as dangerous for the lawyer than to attach his name to the lawsuit. Because I could see where you could be sanctioned under Rule 11 for something like that. But you know, I mean, I guess you could compare it to that McDonald's soup where the guy put the scalding coffee between his legs and then got burnt and actually did recover. So, but that shouldn't be a watchword when you guys are thinking about whether you should file this suit. What you should be thinking about is, well, I'm going to refer it to Natalie instead. She'll take it, well, as long as she's a lawyer. So we've got section 7 to finish, and I'm probably going to start on section 8, even though I didn't tell you to do that. And the reason is for this. As I was thinking about the schedule, next Thursday then is the day of the exam for those of you that are going to take the exam. And so show up and be here. There's an exam for those of you that want. For those that are not taking the exam, you owe me all the questions through section 8. And so what I'm going to do for section 8 is just touch on it tonight, the general section, and I'll put the audio up online because next Tuesday I have to leave for Portland before this class begins. So, because the trial advocacy team is competing for a national championship, so I have to go out to Portland with them. So I won't be here Tuesday. The exam's on Thursday. So for all of you, you'll need to listen to the audio from those classes, obviously read the cases. And they are important cases in Section 8 because this whole idea about arbitrating our disputes as a part of the contractual agreement is everywhere now. Same type of thing with respect to forum selection clauses that you're agreeing to and choice of law clauses. Because the manner in which we do business has changed significantly in a relatively short period of time. And it gives a lot of predictability to the court to know where the case is supposed to be filed, if it can be filed at all, and what law will be used. So the courts greatly favor both forum selection and choice of law and choice of forum clauses. But they also favor arbitration clauses because it saves them work as well, as long as the parties have agreed. So those cases are all reflective of this, the trend in the court and under the Federal Arbitration Agreement, the Federal Arbitration Act, to favor the outsourcing of our civil litigation. But look at it and we'll talk, well, you'll hear the conversation in a little bit. But we have 2 more pieces to do. But I also wanted to touch on Rule 56 again first, which is the summary judgment rule. Summary judgment is what I call the second of our 3 testing motions. It tests the civil action to see if there are material facts in dispute, and I add the phrase that rise to a triable level. And if there are not, then the argument is the moving party is entitled to judgment as a matter of law. And so one way to think about it is that juries determine questions of fact, judges determine questions of law. When there are no issues of fact to determine, then that really does become a question of law as to who wins under the law, and judges are qualified and able under the rules to simply issue judgment without the aid of a jury if there are no material facts in dispute, because a judge can adequately determine how the law applies to a given set of facts. So I call it the second of our testing motions because The standard is what I told you, although some judges interpret it more loosely than others. Some judges favor a jury trial. Some judges favor not having a jury trial, and there's a practical reason for that as well. A jury trial is an enormous consumer of the court's resources. And to the extent that I grant summary judgment, that means I'm not tying up day after day in a trial. Even a relatively simple trial is likely going to take us 2 to 3 days easy. I've had civil trials that have taken as little as an afternoon, but in 3 or 4 hours of time, court could still resolve an awful lot of other cases by way of summary judgment or other dispositive motions and the like. It still takes the court's time, even in a relatively short trial. In a long trial, as we're seeing with the bombing case, as we see in a lot of civil cases, a longer trial is going to consume much more of the court's time. So as a practical matter, some judges tend to be a lot looser with that standard of are there material facts in dispute that rise to a triable level. And the case law, as interpreted by judges, gives them a little more latitude in deciding what cases are jury worthy. When I add the second half of that standard, no material facts in dispute, it would be easy to look at a case and say whether there are material, which means facts of consequence to the law, to the litigation, facts that would be dispositive in essence, to see whether there are material facts in dispute or not. But the reason we add that rise to a triable level is it's not enough simply to say there's a dispute. He says the light was green, I say it was red, but if I've got overwhelming evidence that it was red or green, and all you've got is no, I dispute that, and you don't have any evidence at some point that the jury could look to, that you would be able to prove it. If you remember the case from the CIPRO book that I use, it's a Dickey's versus Kress, where it was the absence of the presence of the police officer in the store was in and of itself enough to preclude summary judgment. And the case where they said, well, what do you have that's introducible as evidence at trial? And that was Celotex versus Catrat, where she was trying to show that her husband was exposed to the defendant's asbestos. And when the court examined what she had to show whether it was in dispute or not, she had no evidence that would be ultimately admissible at trial. And therefore, the fact that you dispute whether he was exposed to it or not isn't enough if you've got no evidence that a jury could consider at trial that would support the item in contention. So what we do now when we look at whether the material facts in dispute is see in essence weigh, and I hate using the word weigh, but weigh the evidence that the party has that supports that dispute of material facts. If you've got nothing, you're going to lose at summary judgment. It is not enough simply to say I dispute it. We're going to be able to look and see what evidence you have that would support the item in contention. For that reason, modern summary judgment proceedings have become relatively complex, whether we're in federal court or superior court, because what the court, correctly, but it's a lot more work than it used to be, requires you oftentimes to do now is with your summary judgment pleading papers. So you have a motion, you have a memo that supports it, you will likely have affidavits as well with those memo and your motion. They now, most courts, federal court, superior court, require you to file 2 additional things, which are an agreed upon statement of facts. What do we agree on are the facts, and where does that information come from? And then a separate grouping of information as to what we dispute and why we dispute it. In essence, where do you have support in the record, whether it's the depositions, the answer, the complaint, the documentary evidence that's been exchanged. Where is it in the record that's been assembled to date do you have that shows there's what we call a genuine issue of that dispute, a genuine issue of material fact? And so what that means is to move for summary judgment, to be able to do all that in a case that's other than relatively simple is a huge amount of work from the standpoint of assembling all that record and finding it and being able to give specific references to it. It's a good process because it narrows your thinking and it culls the massive material you've got down to a usable format. Because if you're opposing summary judgment, you're going to trial. Hopefully you're going to trial. And if you're moving to summary judgment and can avoid trial successfully through this process, it's still good. The problem is, in a less than simple case, we might be talking hundreds of hours of work. Seriously, other than a straightforward, simple couple witness case, you could be talking hundreds of hours worth of work. I told you I have one upstairs. I was wondering if I could give it to you, but I have to redact the whole thing because the case has been resolved and it's a confidential settlement. And the papers are confidential, but it's really summary judgment thing was this thick, no doubt about it. And my guess, the other side was represented by one of the large firms downtown. It would probably have to have been, I did the number at one point, but I would bet somewhere between $75,000 and $100,000 just for the summary judgment motion. Not much doubt, right? What's $200 times? Yeah, that's right. $200 times $400 an hour is $80,000, isn't it? So I would think it's at least that. It's at least that. And so you got to then do all that work as well, depending on whether you're working on an hourly or a contingent, can make a difference. But if you're working on an hourly, you just made a lot of money, a lot of work. And if you're working on a contingent, you hope it's still, if you do it right, you're still going to get paid, but you're not going to get paid on an hourly just for submitting the motion. You got to win.
So in a case like that, where you have such complex motions, and let's say the other side has their cross and their reply that's equally, is it really faster for a judge to go through all of that and decide the case than it is just to shoot it live?
Yeah, it still is, because that case we had estimated, if we had gone to trial, that case was 10 to 14 day trial. Still is going to take a half a month before impaneling a jury in the resolution. It's a lot more work on us, and I think that relieves the court of it. But it also crystallizes what the actual issues are and where the items of contention are and where the support for it is. It's something that would have had to be done had the case gone to trial anyway. It also tells you, as you're thinking seriously about the strengths and weaknesses and therefore the financial value of the case, where it really is and what it's likely to be. And so it's a process that's needed. And if you did more of it, culling the process throughout, culling the evidence down throughout, it wouldn't be as burdensome. But what happens a lot of time when we do civil cases is that after you do a deposition, whether it's a day or a 3-day deposition, that's how most of discovery is. We do a lot of requests for productions under Rule 34 and assemble the information, and then we sort of triage all those documents and cull them down to our top 40 or 50, but there's still a mass of information everywhere in a case of any size. But then what happens a lot of times is you do depositions, so you go there, you spend a day or two or more, and you've got the transcript. The next step, and it should be right away, but the press of time sometimes means you move on to something else, is that transcript, that deposition has to be digested. You have to condense it down. Where are the key pieces of evidence that I got out of this? Where, line and page references that we do when we do our trial stuff. And the computer helps with a lot of this now. The computer will give you you get a manuscript which will give you a word index, and it'll tell you where key things are just by words and the like. So it helps with it. And you can get it by disc as well. You got to pay. You pay for what you want. But a lot of the electronic resources you guys have available makes it easier. But with all that said, unless you've got the staff or someone else that you can say, okay, digest this, you turn your attention to the next file you've got to put out, and only when we're getting further down the road, do you look and say, crap, I got to go through those 12 depositions and digest them, or if they haven't been done well, or they haven't done at all, and we got to grab that information out. It would be better if you did that as you went along, more often, condensing it down, knowing what you've got and getting rid of the garbage. We just don't do it as often as we should because of the press of other work. But trust me, that if you're going to try cases, it's something you need to do with a lot more diligence. And I say that with myself, and I try to do it, but there's always something else.
There's typically a hearing on the motion?
Yeah.
What kind of hearing is that? Do you call witnesses?
No. So then the summary judgment motion, the papers are submitted. And the court, frankly, can review that summary judgment motion and not grant you a hearing at all. It used to be, when I was first a lawyer, we got to argue in court all the time on virtually anything. Any motion you filed, you got an oral argument on. And it was really good experience because you got to argue a lot then. But the modern trend is, as we see in some of these injunctions, we'll hear you on papers. And you do have other rules, like Superior Court Rule 9A, you have a similar rule in federal court now, that there's so much information exchanged between each other in the process of motions that by the time the motion is submitted to the court, they have a pretty complete and thorough record. And in many cases, there are judges that don't feel oral argument will advance the resolution of this at all, and may well decide the motion simply on papers. If you want oral argument, you can ask. Asking doesn't automatically mean you get it. Obviously, I ask and I would like to have it because you hope that if there are questions that even are going against you that the court has, that you get one more opportunity to try and address it and show the court where this or that may be. And for that reason, I think a lot of courts will do it. Most courts will do it, especially in something more than a very basic routine case. But you're not automatically entitled to it, and it simply isn't a lawyer's arguments. It's you and I arguing what the essential parts are, and hoping that if the court has questions going one way or the other, that they'll give us a chance to address them. And it also gives you a leaning as to where they may be going as well.
Can you, in the motion, can you essentially argue facts or evidence that would otherwise be inadmissible at trial?
No.
Can the judge consider? Okay.
Listen, you can argue it, but see, that gets us back to Celotex. If you don't have evidence admissible at trial, then it really shouldn't be considered at summary judgment, because it's not now seen as useful to dispute a material fact simply because you've got that was Celotex. She had information that said he was exposed to the defendant's asbestos. She couldn't introduce it at trial. Therefore, it might as well not exist. So you do, and that's why this whole assembling of the record, you do have to confine yourself to the record that's been assembled. Now, if it happens too early in the case, so that you haven't had the opportunity for discovery, under Rule 56, you can file a 56F affidavit and say, if we get more discovery, this is what we're likely to show, and therefore postpone the hearing. But a lot of times, summary judgment, it can happen anytime once the complaint is filed, all the way up until trial. The later in the process, you should have more of a complete record at that point. The earlier in the process, you may need more discovery to show there are material facts in dispute, and that's where Rule 56F affidavit comes in.
What about affidavits? Because affidavits can be used at the summary judgment level, but won't obviously be admissible as evidence. You have to bring the witness with you at the trial. So,
well, yes and no. Yes and no. Because, well, it depends on who makes the affidavit, right? Because for those of you that haven't had evidence yet, for the most part, an affidavit is still hearsay. An out-of-court statement often to prove the truth of the matter asserted therein, so it's inadmissible. However, it depends on who makes the affidavit. An affidavit made by either the plaintiff or the defendant isn't hearsay at all. So that, if you make that, I can introduce that at trial. But most affidavits are going to fall within hearsay. Some of the others, if we might have a declaration against interest there, if the witness later becomes unavailable and the like, there may be some that are admissible. Most are going to fall within hearsay. But it's not admissible at summary judgment because there is no evidentiary record created at summary judgment. It's, can I ultimately get this evidence admissible at trial? That's what the court should be examining in summary judgment. And that's why I have a little bit of problem in that Celotex case, because I do still believe some of that evidence would have been admissible at trial. Other lawyers could have got it in, but I do think I could have got some of that in. I don't believe the court was correct in their interpretation that all of her evidence was inadmissible. But that's what they look for. The affidavits, obviously, at trial, most wouldn't be admissible, some might be. Okay? Questions? At the end of the day, to me, it's rare to me, I represent plaintiffs for the most part these days, almost exclusively these days. It's rare to me that a defendant doesn't try a summary judgment motion. And when they do, I'm kind of surprised, simply because, what the hell, nothing ventured, nothing gained. That's why I call it a testing motion. If you're the judge of the cases before leans more to jury trial, then I'm in good shape, but I still would file it if I were the defendant. If the judge doesn't, and a lot of judges have a more elastic standard, then you've got nothing to lose at getting some insight from the trial judge that will ultimately hear the case. So it's a very involved and important rule in civil proceedings. And surviving summary judgment, obviously, is, from the plaintiff's perspective, what our goal is, because if we can survive summary judgment, then we get a jury. And the uncertainty of a jury trial for most defendants means they have to be a lot more serious about taking that risk and going to trial. And that's why, if you can survive summary judgment, we still see a relatively small number of civil cases get tried. But they do get tried. And you got to survive to get there. And summary judgment is often used to try and preclude your desire for a jury trial. Anything else on summary judgment? It's a lot of work. You got to obviously write your papers and be able to write effectively and gather all your information up. But once you do, you then have your blueprint for how your trial gets done. So it's what you would have done at some point to try the case, to have it all in a nice, useful manner. Just there have been weekends lost where you say, I'd really rather be out in the sun, but that's just not the life you chose. You chose to work in a library for the most part. So let's talk about Brandling and Kaplan. We don't work in library settings. We just don't like the time we do. So I talked to you about this case, and I asked you questions about it the other day, briefly. So he ends up settling for 5 cents on the dollar. Is that what you're supposed to do? You're supposed to just ask for the moon and the stars, and if they give it to you, great. But doesn't that make you look ridiculously unreasonable? Well, there's nowhere to go but down, and if I make a low offer, I can't go up. So you start ridiculously high like he did, and then you don't lose some credibility. You don't lose, because he did lose credibility, but it didn't matter. He won this case, right? He says no matter what, you had to make a reasonable offer. You at least had to respond. Your failure to respond is a violation of 176D, and therefore, since you violated it, I win, and you owe me now. And the court agreed with him. The obligation is on the insurer to be reasonable under all, to respond, and then if there's liability, to be reasonable. And since they weren't, they owe, no matter what.
Well, what I found interesting is $90,000 for the husband, but $900,000 for her. The disparity between the two amounts was probably, in my opinion, made him look like he had really no idea. He wasn't reasonable with his request for $900,000 if you're going to ask for $90,000 for one. So.
And that's just the way it goes, because he doesn't have to you don't have to justify your demand. By the way, with saying that, a good demand lays out how you're getting to the number. Even if the individual elements of it are outrageous, mathematically at least it gets us there. And it does give you a point for a starting point for discussion. Look, you have $900,000 in pain and suffering. How are you getting there? And so it gives us a formula. So when you're making a demand, it is important that, I think it's important to be credible. You're going to be high, but it should be credible. Here, I know him well. I tried a lot of cases against this guy early on. I just wonder how you're able to really justify it when you really do have a six-figure case and you're trying to make it a low 7. And listen, we'd all like more money, but I think the reason they didn't respond is they said, this guy's crazy, he's out of his mind, there's no obligation to, they were wrong. But at the end of the day, they don't think that they've got a point of discussion to even begin with, the way it actually works. What's also interesting about this case, and I want you to think about it, and it's one of the few cases, that's why it's here, because it's got an unusual history. This is one of the few cases under 176D where it actually says it's not the contracting party exclusively who has a claim against their insurance carrier. Even the other party has a claim for violations of 176D. You're not going to see a lot of law that actually says that, and there is some real question about whether that is in fact accurate. But that's what this case does. If you look at footnote 7, Judge Mazzoni says he's puzzled by the fact that the insurance carrier didn't even make an argument that has significant legal merit to it, is that they're not in privity of contract, they don't have even a right to make this claim. They never made that argument, which struck the court as unreasonable. And to me, I don't understand why they didn't do it either. But he didn't do it, they didn't, the insurance carrier didn't do it, and so therefore the court is going to enter the order. It was, as the court looked at it, and it talks about 93A, again, you should start to think about 93A and 176D, talked about them before, as the relief, the extraordinary relief they provide. At the end of the day, the fact that he settles for about 5% of what he initially demanded doesn't mean that they didn't violate 176D, and so he wins on that score. I gave you another little piece of this case because I think it is unusual if you look at it. This case was obviously then settled after this decision because I don't believe the insurance carrier wanted the precedent on appeal. And so they likely paid a premium to have, in essence, this decision wiped out. And that's what they did, is even after this decision came, they, at that point, decided to settle. And if they're settling at that point, then they're going to pay a premium, because you're asking me not just to settle, you're asking to wipe out the earlier decision, and they're trying to wipe it off the record at that point, so that other insureds can't use it against them later down the road. So kind of an interesting procedural history on that as well. Let's talk a look at Kaplan versus Fellheimer. And lawyer gets sued. The plaintiff strikes a deal with the insurance carrier, and he was sued because the firm created a hostile environment for women, sexually harassed the plaintiff, and then sexually harassed the secretary, and then Kaplan, who spoke out against this, was then fired in retaliation for voicing her complaints. At some point, the insurance company strikes a deal with her for $190,000. In 1995 money, that's not nothing. It's not nothing today either, but $190,000. And obviously within policy limits. I meant to talk a little bit about that quickly. When we're talking about 176D, we said that there's an obligation on the insurance company to defend under the policy, defend the insured, to when liability has become and to respond, as we saw in the last suit, to respond to demands made, and that once liability has become reasonably clear, to make a reasonable offer of settlement on the claim, which they don't like to do. And they don't like to do it because that's why they get to be in those big buildings, because they don't want to pay claims. They want to make money. And this becomes a tension, and it becomes a source of issue and sometimes work for you guys. So your client, someone who has been a client, someone who's a friend, they've been in a car accident, they have a policy that covers them. Under that policy, they're entitled to defense by the insurance carrier's lawyers. Lawyers selected generally by the insurance carrier. The insurance cares about the policy and the policy limits. All insurance policies have limits. A lot of your automobiles probably carry what we call 20-40 coverage. $20,000 for each person injured, up to a max of 40, no matter how many people are injured. You can buy more coverage on your vehicles for relatively short money, and you should, because 20-40 isn't going to cover much of a personal injury accident at all. But what that means is the insurance company, in addition to their obligation to defend, is only obligated to pay that person injured, we'll assume one person's been injured, up to $20,000. Whatever the judgment is that comes in over 20 is the insured's obligation, your client's fault. And this is where the tension comes in, is that, so your friend, your client, whoever comes to you and says, well, I've been in an auto accident, they're going to get me a lawyer. Great. They'll pay a lot of money to defend that suit. They still need you. And they need you to keep the insurance carrier honest. Because the insurance carrier doesn't even want to pay that 20. Now, they have an obligation, once liabilities become reasonably clear, to make a settlement offer and to pay up to policy limits. Okay? But they don't want to do that ever. I hate to keep telling you war stories, but I had one. My son, when was in college in Rhode Island, was in an accident, serious accident. Well, it was a serious accident. I don't know what my coverage is. I think the coverage at the time was $250,000 per person, $500. How many people injured? There's only one person injured. They had a lawyer in Rhode Island that the company selected to represent me. That's what they did. And so, case was tried by one of these billboard attorneys down from the plaintiff's side down there. And I fought with the insurance carrier throughout because there was no liability. The other party ran the light and hit the car. But she's 90 years old, and ultimately, within some relatively short period of time, not as a result of this, but she died. So now we have a dead plaintiff who was at fault by all accounts, but you try cases, you don't know how they go, and had maybe about $40,000, $50,000 in meds directly attributed to this. It's a no liability case. It really is. But if you're the insured and you've got a $250,000 policy, to me, give her $100,000. Give her $150,000. Give her $200,000. I don't care if you give her the whole damn policy, because I don't want an excess judgment here on a claim that I shouldn't be liable at all. So the first $250,000, I don't care, right? At least part of the argument is there's no liability. Why should we do it? Because you should do it, because if it comes in at $500,000, the next $250,000 is going to come out of my pocket, and I don't have $250,000. So you've got to push you on behalf of the lawyer, me on behalf of myself in this case, have to push the insurance carrier to make an offer. Offer the whole policy if that's what it takes to go away. And you have to invoke 176D at times to do this so that they understand that there is potential attorney's fees and multiple damages if possible. At the end of the day, they chose to try the case. I didn't want them to try the case, and I was batshit crazy, even though I expected a no liability verdict. And so I said, if you try this case, and I did obviously a formal demand, you try this case, then you've got exposure here under 176D, and I expect then you to cover the entirety of the judgment. Before that case was tried, we had an agreement that regardless of what that verdict came in at, that they were going to cover the entirety of the verdict. And that's what you have to do, because they don't mind risking your money, because what's the worst case? They want 250, our policy's 250, they have nothing to lose. I have a lot to lose under those circumstances, and that's where there's real tension as you start to think about the insurance company is going to provide you counsel. Because what they provide you is either captured counsel or even now in-house counsel because it's cheaper. And so, are they really working for me? No, I don't send them business. They don't know me. I never even met this lawyer. He met Michael, because Michael was the one driving the car, but he never met me. He kept me in the loop, and I think the reasons he had to keep me in the loop was a pain in the ass. But they tried the case, and it was a no liability verdict, and he was right. But I've been there too. Okay, so hindsight's 20/20. Okay, you were right. Yeah, what would have happened if you were wrong? And that's the thing. That's where there's tension here. You got to recognize it. So you can't just tell your clients, "No, you're all set as long as you've got the insurance company lawyer," because there is a limit to their policy, and they don't want to pay that whole limit. I've had carriers where they said, "We're kicking in the whole policy," virtually right away. Good carriers, but they're not all good, because to the extent they're rolling dice, they figure they have nothing to lose. If this verdict comes in, it's coming in. It's $50,000 in Mets. It's with a death even that they can't connect. It's going to come in at $250 for them. So why should we pay $2 if we don't have much more to lose? And that's where there's tension here, and you've got to hold them accountable. 176D helps you do that, and you can work agreements beyond. Well, then if you want to try and roll the dice, then you agree to indemnify me for any costs that go beyond this. And that case didn't even end at the trial level. The bastard took it all the way up to appeal, all the way to the Supreme Court of Rhode Island on a case that he didn't properly protect his evidentiary record anyway. The other lawyer was just out of his mind.
Can I ask a question? It's about 93A stuff.
Yeah.
So say you are representing a plaintiff, okay, and you file your 93A with the defense, and they don't give you a reasonable offer, and then it's come that there is liability, and then you go to trial,
Yep.
and you get a verdict,
Yep.
and you get punitive damages as well as your regular verdict, right? Let's just hypothetically speaking, if you win.
Who do you have for Overthrow? I know who you had. We don't talk about punitive damages here.
All right, but can I just ask you a quick question though?
No, let me scold you first, and then you can ask your question, okay? Because these guys have all heard me a million times. You guys love your punitive damages, but there are so few cases in Massachusetts where you actually are awarded punitive damages. Harassment cases, discrimination cases, wrongful death. That's about it, okay? Every other case is actual damages. And so that's the first phase. So wipe the notion that it's always gravy train in punitive damages. And here's the other related point to this. 93A is actually, as you might guess, in partly punitive, right? Because we double or treble the damage plus give you attorney's fees. So to the extent that that already is a punitive measure, which it is, you'd have to have another count, another theory, where you would be able to entitled to collect punitive damages. It is a harassment case. It is a discrimination case. It is a wrongful death. That count, then potentially you could recover punitive damages under. And then you have the election that we saw in Pier 4. Do you want your reliance damages, or do you want your expectancy damages? When we bring a multi-count complaint, 5 different counts, we submit that evidence to the jury, and they come back with verdicts. You don't get the collection of all 5, because you've simply had a legal injury. You had various legal theories you advanced that supported the claims you asserted. At some point, you got to decide, and it's at judgment, which one do you want the court to issue the actual execution and judgment under? So what you do under those circumstances, so I have a 93A count. I have a discrimination count. I have breach of contract, tort, false imprisonment, whatever else it is, and not uncommon. What you do then is when the jury comes back with their judgment, and they would have jury interrogatories or special verdicts with a multi-count complaint like that, you look to see, A, which one gives me the most money, and which counts are likely the most supportable on appeal in the event they're going to appeal it, right? And so then I'll take the judgments of the ones that are most bulletproof and the highest. So the likelihood is I've got a 93A count. I may have a different count in legal theory that would support an award of punitive damages, but I'm not going to get both at the end of the day. I'm going to pick the one that gives me the most. Right, that's your question, right?
Right, because the firm I work for does all wrongful death.
Yeah,
So they
so you get
always
punitive
file
damages.
93As, but I didn't know if you do get punitive damages, if you can get treble punitive damages, or it's just based on the firm, like is it based on all of the damages together that they come back with? That you can get treble damages if the 93A comes back as not a reasonable amount, or they took too long? Like, what do you get treble damages on? The total
On the
amount?
actual damages.
So punitive?
No,
if you get
no.
punitive-
Actual means the non-punitive
The non-
damages.
okay, that's
Your
what I meant.
general and special.
Okay. You can't get treble damages on your
So
punitive?
nursing home cases?
Yes.
And so he's arguing that those are, that
Well, it's like,
within that's fraudulent deceptive practices for wrongful death?
so they filed the 93A.
Yeah.
They came back with an amount that was very, very low. It
Right.
came that there was liability,
Right.
right? So then they went to trial. So then they got a verdict, and then they got like 1.4, and then they got 14 million punitive, right? So now they're going to seek for treble damages because of the 93A claim. So I didn't know if they're...
I don't think you're treble, I don't think you're going to...
That's what my question is.
No, yeah,
Can they
that's a
get
nice
that?
question, nice question to have.
'Cause I'm
I don't
gonna
think
ask
you,
them.
I don't think you treble the punitive. You could treble the actual to 1.4 on the 93A
Okay.
count. Did they find it was 93A violations as well?
That's why, yeah.
See, I'm having trouble wrapping my head around how wrongful death becomes fraudulent deceptive trade practices.
Well, because when they filed the 93A claim, well, yeah, they filed...
They failed to make a reasonable offer of settlement.
Right.
That's how it.
Right.
But what was the action, the consumer v. business action that was considered fraudulent and deceptive? That's what I'm having trouble with. Where's the origin of the 93A? It's not because you make the demand because there are fraudulent and deceptive trade practices that you think are covered under 93A. They then have an obligation, nonetheless, to make a reasonable offer of settlement, or at least to respond to the 93A. And I'm just wondering how, in the nursing home context, you would get fraudulent and deceptive practices.
I think because initially there was a DPH report that showed clear liability, and when making the 93A, that information was along with the 93A, that there was clear liability. The DPH found there was on the part of the nursing home and the administrator. So then, when they responded, knowing that, and they laid out, what they usually do is they lay out in the 93A where the liability would come from,
Yep.
and the amount where it would come from. So when they gave the amount back, it was very, very low as to
Yep.
not even taking into consideration the DPH report, the liability, and the breakdown of it. So then when they went to trial and they got the verdict, I think they're being awarded treble damages, but I just didn't want to ask if it was on the punitive damages.
Why don't ask him? He'll tell you.
I know, but I don't know, it's kind of...
I'd like to know. Now you're going to tell him. You don't tell him we talk about it necessarily unless he tunes in. No, but I
Because I'm
really
curious
would
to
like to
see.
know. I don't think you're going to find the
Because I've
trebling
been
of the
getting
punitive.
raised.
I think you'll find a trebling of the 1.4.
Okay, okay.
But I'm even wondering how you collect the trebling of the 1.4 plus the punitive, because 93A by double and treble plus he's got attorney's fees.
And he has, right. So
See,
that's
I
what
would
I'm
think,
confused about.
without looking at the present status of the law, I would think he gets the 1.4. He's got an election. No, because he'd be entitled, well, he's, okay. 1.4 treble, say,
Yeah.
plus his attorney's fees. Or 1.4 plus the 14.
Then,
That's it.
okay.
Right? If it's the 93A, he's got a 1.4, treble that, plus the attorney's fees, plus interest. Or 1.4, which is his actual damages, plus his punitive of 14, plus interest. I don't see how you could get the trebling of the 1.4, because that is punitive, the 14, plus the attorney's fees. I mean,
I don't think we'll ever know.
I would fight for it too. There does seem to be
I just didn't know
a couple
what
layers.
treble.
It seems like a couple layers of punitive to me there. But I'd be interested to know what the answer is.
If you
And I hope he
succeed,
gets it.
if you succeed on a 93A claim, are the attorney fees discretionary?
No.
Are those, and how about the doubling or tripling? Is that discretionary?
It's discretionary between doubling and trebling. but there's case law that says it must be at least double.
Oh, really? Okay.
Yeah.
Here's
Go
a
ahead.
question. If I, this real simple one, I get in an accident, it's clear as the other person's fault, we file the insurance, I got 50K real damage meds or whatever, they play around like they did in the previous case, and finally, we get a judgment, 170/60 and all of that. Of the damages that get doubled or trebled, is it the 50K or is it the amount of losses that I have because I didn't get paid forever?
Yeah, and they struggle with that a little bit as to what the actual items would be, as to what the valuation of the damages would be. Is it your losses because they didn't pay you the 50, or is it some multiplier of the 50 because they should have been more reasonable from the outset? That court has leeway with respect to how they're going to calculate your actual damages under the circumstances.
So if they were 50K meds, they could say, well, you only suffered 2K in damages because they fooled around with interest and other things that you had to do.
The court could.
So it could be 2 times 3 is 6.
Your
so I
actual-
get the 50 and the 6.
Exactly, your actual losses.
Yeah.
But plus though, and this is a big get, that this is why we pleaded that you really have to recognize it. The award of attorney's fees under 93A and 176D is massive in a civil suit. And because it is easy on anything other than a simple case that actually gets all the way to trial to be invested in over 1,000 hours. Right? Ask him out of curiosity. Ask him out of curiosity if he'd be willing to share how many hours they.
Well, they sit there for 4 years. Like, we have cases that come in that sit
Right.
and get tried after 4 years of sitting there.
But ask him how many hours he's putting into. And other big cases, obviously, the wrongful death cases from nursing home and nursing home liability cases. But I'll bet if he gets his attorney's fees on that, I'm going to guess north of 2,500 hours.
I would bet. Yeah, I would bet.
Okay. One more. This is really fast. If you get somebody on 93A, let's say it's a startup, for example, you're suing them for some unfair business practices, and they get this triple judgment and attorney's fees, can they bankrupt out of it and escape those?
Yeah, in this, we haven't really talked about this, but this is why we talked about it at Civ Pro. This is why you got to pick and choose carefully who your defendants are at the outset. And there's no value in bringing a huge case against a defendant who doesn't have assets. And so you sue, Local Media Inc. And you engage them in this fight for years. And then you get your massive judgment. And the next day they go bankrupt. You're out. You're out. And this is why sometimes we look at the outset for a bunch of things. First of all, is there any individual liability that potentially attaches? Because then I'm going to bring you all in, and as many parties as I can, and even an individual, though, can go bankrupt. I want to look for assets at the outset. I might want real estate attachments, and I do want real estate attachments at the outset because the litigation can take 4 years. Nursing homes can change hands multiple times in 4 years. Insurance carriers can change multiple times. So I want to start to secure assets from the outset. If I'm bringing a nursing home case, I'm probably going to I'm going to try and attach the real estate from the outset. I'm doing it for 2 reasons. I want to flush out the insurance because one way you can oppose the issuance of the attachment or an injunction even, but I don't want injunction. I want attachment. Is to say, because the standard for an attachment is we expect to establish liability over and above any insurance shown to be available. So this is going to flush out what that policy is for me, and who it is, and so if they don't want to play that card, then I want to protect myself as a lien against that real estate. But this becomes really important to know at the outset that it's not just that this is a defendant who's going to be around for long enough that I'm going to make money on this case, or I'm going to try and protect myself at the outset, because there are cases that are worth a lot of money that we have to settle early or late for short money because they don't have it. I tell people my uncle was injured in driving back from Florida, get hit by some 18-year-old kid with a 2-year-old in the back seat, lived somewhere in the Carolinas, in backwater Carolina, doesn't have anything, isn't likely to ever have anything, hit from behind. It's a $50,000 case, that's it, because that's the policy. There's nothing else that's likely ever to be there. So the value of cases isn't just reflected in liability and damages, it's reflected in what's there. And so, yeah, they can avoid liability
Yeah.
by going bankrupt.
Yes.
And that's the other thing, like Pier 4, they'll transfer assets during the course of the litigation to try and minimize it. That's why we got to look at the outset.
Attach first, right?
Yeah, you got to attach at the outset, because that's the only way to ultimately protect, to make sure. Because in a case like that, the cases I've talked to you about, I could, civil pieces, I oftentimes, but my cases tend to be bigger these days, I'm north of a couple thousand hours in most cases. A couple thousand hours is a lot of money if you put all that time in, and then there's no money at the end of it. So you got to try and figure that out, because if there's no liability, if there's no damage, or there's no money, it's sad to say, if you're not getting paid on an hourly, their case isn't worth taking. And if you're getting paid on an hourly, by the way, you still owe your client the same obligation, in my opinion, to say, listen, you're going to pay me $400,000, $500,000 here. I don't think there's money at the end of the rainbow here. And that's something that you ought to tell them at the outset, because when we have this conversation at the end and say, hey, I got you a judgment, and it's worthless, well, why'd I pay you all that money? And that's so it becomes a problem. We're going to get back to Fellheimer. So in this case, it's a very, very odd situation. That's why I wanted you to read it. Here, the insurance company wants to settle. They want to pay her $190, be done with her. The lawyer doesn't want them to. The lawyer says, you can't settle over my objection, right? And so I'm wondering about the odd situation where, under what circumstances they can settle even when the insured doesn't want them to. Because it's not the case. Usually you push them to settle. You demand that they settle, to make those reasonable offers, because as long as they settle within the policy, it costs you nothing. And that's obviously the ideal situation. That's what your clients want. They want to just walk away. But here, he doesn't want it. He wants an apology, right? He wants a retraction. And by the way, $190,000. He doesn't deserve any retraction, because they wouldn't be paying $190,000 if they didn't think that there was exposure here, likely liability, and a much larger judgment. They wouldn't be coughing up nearly $200,000. So he just wants the apology to smooth over his good name, so people wouldn't think he'd do something of this sort, which he clearly did. If they're paying they're paying her $190,000. Can they settle even over the insured's objection if they deem it's in their best interest? Because see, that's the other part of it here. No, I want you to try. I've got $1 million policy. Try it. Don't give that bastard a dime. Be vindictive. Be whatever you want, because I don't like them. So I've got $1 million policy. I've got no exposure. You try it. Well, insurance companies looking at it, well, we might have $900,000 worth of exposure here. She'll settle for $2. From a business standpoint for them, if there's clear liability, if there's clear damages, to pay $2 to get rid of a $900,000 likely judgment, that's a steal. So under what circumstances can they settle within policy limits over their insured's objection?
Well, the issue here was if they did it, then it forecloses his counterclaim, right?
And that's the problem, right? Is that he actually has a claim advanced. And in order to extinguish this action, they're going to foreclose his opportunity for his counterclaim. And that's where the problem comes in. If you look, it's on page 501, they talk about this. And this is an unusual situation, but there will be times when people will get up on their pedestal and say, no, don't give them a dime. And if it's not going to cost you anything, what do you care? Well, the insurance company still cares, because it's a business for them. It says, insurance company settles in bad faith. And that's the question. Are they doing this in bad faith? If it settles within the policy limits, if the settlement is contrary to the intent and expectations of the parties. It says a bad faith settlement could be found in two situations. The first situation would be an insurance company settled with some of the plaintiffs for the full amount of the policy, leaving the insured liable for an excess judgment to the remaining. That's a situation where we talk about you got $40,000 in total coverage for however many people are injured. If I give that 40 to the first two people that make the claims, then everyone else is outside the policy and the insured is paying them directly. They say, you can't do that. You got to do better than that. You got to defend. You can't settle with some and leave the insured liable like that. But that's not the situation here. We've got one plaintiff who is, in fact, offering to settle and they want to. They say the second situation happens if the insurance company settled without regard to the fact that it may be barring a counterclaim of the insured. And that is precisely what's going on here. He does, in fact, have a counterclaim. He does, in fact, if the case goes forward and it settles, he'll lose his rights to advance the counterclaim. And so what do we do now? Because they're pretty far down the road with respect to the settlement and the like. But if the plaintiffs, if the plaintiff is going to be harmed as a result of the settlement, then maybe he should get his injunction. He wants this retraction to repair the damage done to his reputation. Let me ask you that, and I think I've asked you, I know I've asked some of you before. 200 grand, that's a lot of money. Would you tell a client to just apologize? Just say, it didn't happen? What the hell, you're getting 200 grand? No? Would you tell a client to do something? Because what does it matter? Does it matter that she retracts her claim?
Makes her look bad.
Yeah,
Okay.
I think for some people that's worth more than the money.
Is it? So I'll give you 3.
But you're laughing all the way to the bank, so what does it matter?
I mean, there's a price. I mean, don't get me wrong.
3 might do it instead of the 1 night.
I could go and say Agent's Cape is good, but I mean, it's going to be a pretty steep price.
Well, so that's all. You'll pay a premium for the apology that you're not due. Would you tell the client to do that? Because listen, they always do. They come back and say, well, what would you do? Would you recommend that I do this? So I'm just wondering. Listen, it's more than you might get. It's more than you get at trial. They just want the apology. Apologies, to apologize, because it doesn't that stick in your throat a little bit? Or I'm just wondering. You should say you're sorry when you're sorry, but now I've got to say sorry for someone who actually did what I said they did. Now I've got to say I never should have advanced this. I mean, I've got your money, and you're right. I'm laughing all the way to the bank, but I wonder what your advice is to them, ethically, morally, or otherwise. Or who cares? It's 300 grand. Do your math. A third of that is a lot of money. So, what did you say?
About like 90 grand.
A third of 300 is going to be 1. Okay. So, you tell them to do it? Or do you play with the language? Well, because maybe that's it. Maybe we can save face. We're lawyers, right? We can create language that says something that might get close. Or do you just tell, and the other side is, we'll try the language, but at the end of the day, would you tell them to do something that you know, they know? It's a lie, right? It's a lie. Didn't your mother tell you not to lie? Would you tell them now as a lawyer to lie?
Frankly, you can say, look, if they're going to give us $300,000 and you're going to write an apology, only the most simpleton would not understand that they really did it. You know what I mean? It's not like you're saying to them, hey, go say that all this was a farce, because that $300,000 conclusively established it was, right? So, I mean, there's a little bit of that played into this as well, right?
Right. So do it. So would you do it? I'm your client. Should I do it?
Do you want $300,000? I think that's the real
Well, I
question.
thought you were taking a third of that. I'm only getting 2, right?
Do you want $200,000?
Yeah.
I'd like 200. Is this the best deal you think I can get? You think I have to do this if I want the 200? Think I should do it?
choice, it really is. And some people.
So is that what you tell, it's your
It
choice?
really is, it really
So
is.
is that what you're telling me? It's my
I
choice?
really would say this is really your choice. And in some situations, I think many people would go, no, I'm not doing it, not for a
Do you
million.
really think many people would?
I don't
You
think
think most
many, but
people- I
some
mean-
would. Some would.
Do you? Or, see if you give me another 50,000 and I'll do it. Would you do that? So,
Well,
you give me
I-
another 50,000, I can't, I will.
Yeah, we get $1 billion, everybody's gonna do it.
Huh?
No, well, if you let them know that if you go to trial, you might not,
Well, what if the number, let's be realistic, sometimes that number is just about what if everything goes well,
Yeah, that's-
you're gonna get about 300,000. But let's be honest, not everything always goes well. Judge gives us rulings at trial on what we expect should be admissible evidence and they're not. Jury doesn't like you, they look at you and say, I don't know. You try a case, you have an expectation of if everything goes well, what it's like. And I'm telling you, if everything goes well, you're not likely to do better than 300. And they're offering you 3. All you gotta do is say, it never happened. I shouldn't have brought this claim. I'm sorry. So what you
Just
know?
tell them to say it with that smirk you just had.
No, is that,
I don't think I would do it.
you would not do
Well,
it?
because that's such a reflection on you as an attorney.
So if they did it, you would tell them, and you keep your damn $100,000.
No, I take it.
So.
I'm entitled to that 100 grand.
I thought you were just telling us you were feeling dirty about this and wouldn't be involved.
I think if they wanted the money and I said it is your choice, but if they go ahead and do say that, regardless if you get your 99, that looks really shitty on your professional.
So you better take that 100 just to make things a little
I'm not
better.
gonna look shitty and have no money.
Fair enough. That seems reasonable. In a very odd way.
It's a lose-lose for you.
It is a lose-lose.
Isn't it?
It is a lose-lose under those circumstances.
And you look stupid in the court's eyes, which sucks, because you're gonna probably have to go back to that court, and they're gonna say, you know what?
Well, how do I look stupid? I'm wondering about that, because when we settle a case, it's simply a stipulation dismissal with prejudice. So he's got his apology, but what's going to happen, in a case like this, is when I guess you don't have confidentiality provisions, or you probably do on the amount.
Yeah.
But he's authorized to say, we're not going to disclose the terms of the settlement, other than saying the plaintiff acknowledged she regretted bringing this action and she was sorry to make these false accusations. I can say that.
Oh, I won't, there's
No,
no way.
there's
we're
no
gonna-
way.
Absolutely.
Yeah, no, let's load up the trial,
Have to be
we're not gonna do
assumed.
that.
Well, what were you thinking the apology was doing, though? So
I didn't think
I
it
can't
was
tell
going down.
Huh?
The plaintiff, that the parties have reached a settlement and leave it at that and not disclose. the-
Oh, so it's a private apology in the agreement, Dad. I don't think that's what he wants.
No,
he's not gonna want that.
No, it has to be a public one. If you can't tell the money, then there's no way we're doing it.
Oh, but the undisclosed settlement, like the imagination is greater than anything.
Absolutely, awesome.
Right.
I can't tell you how much we've got, but we are happy this is resolved.
So I think you're still right about, that settlement shows that your apology is a farce.
Yeah, but I think the other side's smart enough to know that there's no way they're gonna allow you to say that. I mean,
What do you
it
mean?
nullifies it. I mean, if I'm defending these creeps, which I wasn't,
Yes, you would.
there's no way I'm gonna let this be where, an undisclosed amount of money went out and we got in our apology. Everybody's gonna go, that's stupid. Like, it's a really ridiculous offer.
Well, is it? Okay, 450. You've already told me there's a number. I know there's a number for all of us. And it's not just us, there's a number for them, right? There's a number for them. And so it's a question of, to what extent is this, it's certainly disingenuous, sounds immoral, probably not unethical, I guess, because lawyers have a very odd sense of ethics, it looks.
Can you be disciplined for it? 'Cause then
For what?
But under the ethics rules, then you would be perpetrating a lie here. You can't.
To who? Not on the court. All the court gets is a stipulation dismissal with prejudice. We are done.
So it wouldn't come back to.
It wouldn't come back
like
to
a frivolous
it wouldn't come back to an
lawsuit
ABA.
beginning?
No, we would put in the release, and you would make sure this is in the release,
Right.
that we're waiving any claims for, because you're absolutely right. If you need language in there about this is it between us for anything ever between us up until the time this agreement is signed, because, and maybe even after, frankly, because I don't want libel suits either. So, I mean, you'd have a bulletproof agreement that there's going to be no Rule 11, there's going to be nothing else that you're going to be able to try to, and you better have that in. You're absolutely right, because you don't want that coming back. But the stipulation of dismissal with prejudice should end the Rule 11 argument, but you would put language in there to that effect as well. So,
I don't know, the fact that she's an attorney now, you know.
so tell me what you do, because there have been a couple where they want apologies, they want you to retract the allegations, they want you to, listen, they want you to destroy all the documents you've got, they want the entirety of it confidential. I don't like to destroy documents, I'll return them to you. You do what you want, but I don't, by the way, destruction of evidence, and it carries with it both civil and potentially criminal penalties, so you've got to be careful with, I don't like to destroy stuff I've got. I'll give them back to you if that's what you demand as part of the settlement. And that's on you as to what you do with them.
With this case, I was thinking about the employer, and if I was his lawyer, I would be upset that he's going to screw this good deal that I'm about to get him because he wants an apology.
Here's your problem with that. But we all know who you are, and we've all seen this. Did you see the case yesterday? Court Officer Lawrence was arrested for raping a shackled prisoner. I hope there's ample evidence to support it, because the picture's been all over the news, it's in the newspapers, everyone knows the story at this point. And something like this, in the legal community, you know, when something like this comes up, you say, oh, Andy's firm, no surprise, right? No, but so, and we actually had one in Boston. I'm trying to remember what the firm was, but we had one like this, and my recollection, it was a couple of guys, and there was a sexual harassment case, and I can't remember the rest of the case right now. And of course, everyone's talking about, geez, I can't, imagine what was going on because of the problems with it. It was a significant civil suit. I want you to think about that. I would just, at the end of the day, the client is driving the bus on settlement. It's their choice. I do think, I am a little troubled when, the sort of the notion is I'll sign or say anything as long as I'm getting my money. But they're probably going to ask for your input, and I don't know, is that legal advice, is that moral advice? Because at the end of the day, they likely need the money, but you hate to participate in what does sound fraudulent, deceptive, immoral, whatever you want on it. I'd like to try and work with the language first to see if there's something we can live with, and that's usually been my fallback, is to try and find language that is sufficiently lawyerly weaselly that it isn't as bad as it could be. Let me talk a little bit about the next section, so that as you think about it, you can look at those cases. As I've said from time to time, this whole notion, and you guys who were with me, you read Carnival Cruise Lines versus Shoot? Did you read that too? Okay, because it's a great case. It's 1991, so it's quite old at this point. But it used to be, when the court was originally starting to interpret these choice of forum, choice of law, choice of required arbitration agreements, they would look at bargaining power between the parties, and they would look at whether it was freely entered into and all of that. But Carnival changed that, and some of the other cases have as well. What it seems to say now is that if you had an opportunity to know that that provision was in there, and to digest what that was, even if you didn't digest what it was or ultimately know what it was, but you had the opportunity to be aware of it, and you went forward anyway, then you're bound by that provision, regardless of whether it's the consumer, like it is in Shoot, and the largest cruise line in the world, as it was in Shoot, and there was obviously no real bargaining power between them. You either took it or leave it. The fact that they had the tickets, had an opportunity to review it before going on the ship and did go on the ship, meant that they were bound by that provision, even though, if you remember the facts in Carnival Cruise Lines versus Shoot, those tickets were non-refundable. So they were not without some peril if they chose not to accept the terms of the ticket. It almost doesn't matter anymore. When you guys are clicking through I accept online, you're doing, you're waiving all of that. You could be aware of it. The fact that you choose not to be is shame on you. And so you need to think about these cases as we start jumping from Carnival Cruise Lines. And the other cases are all just other interpretations of, under what circumstances that arbitration agreement will be enforced. What do we do in the meanwhile for the arbitration agreement? There's some ways out, and that's the Rosenberg versus Merrill Lynch, where they're trying to suggest that the arbitration process is rigged. It isn't fair with respect to the manner in which it's administered, in that case as against females. And look at those cases carefully, but what you're going to find through them as you think about them is that the FAA favors arbitration, Federal Arbitration Act. The courts like it because it saves them work. And it's not just in your consumer agreements or business agreements you make. Some of you may well have them in your employment agreements, waiving various claims or forums that you can go to. And I think I told you, I think we saw one in a related issue. My daughter, who's 24, has had 2 different jobs in the last year, both of which required both non-competes. And not big, not, big executive level jobs, but both jobs required non-competes, required arbitration and choice of law provisions in them. And frankly, there's no reason why every employer wouldn't choose to require you to waive your jury trial, require you to waive access to the court, and agree to a relatively streamlined process of arbitration in order to be able to take care of these any disputes that you may have as a result of your employment. Our profession is changing because we've become too expensive. So businesses are looking for ways to save money. Law firms have to streamline their services and the like. And this is another piece of this, is that to the extent that the business says, I'm not going to pay lawyers $250,000 to litigate someone's Family Medical Leave Act claim, or their claim of harassment, or even just the claim that they didn't get overtime when they should have gotten overtime. And those cases are everywhere too. Let's go to arbitration in a relatively streamlined fashion. We'll have it all done within 30 days. We're not going to spend the type of money on legal fees that we would have. And no matter what, from a business standpoint, I know what my number is and I can move on. The predictability, the speed, and all, a lot of that it dictates against allowing employees and others to be able to use the court system. The problem is we're creating a private body of law that we don't really know about, and we don't necessarily have access to those decisions, and it can be quite problematic at times. So read the cases carefully. I think they're interesting. And the last case there is Circuit City. They have an agreement yay thick that they used to, Circuit City's gone, but they had people sign even for the most menial jobs at Circuit City. It's something significant. Rule 23 is class actions. We can talk about that next time. I'll also put it's on the audio as well. But we'll talk next time when we meet, which will be a couple of weeks actually. So those of you that are taking the exam in this room on Thursday at 4:30, I'll put the audio up for these classes so you have the audio to listen to. Those of you that are not taking the exam, the in-class students who are not taking the exam next Thursday, have to have all the 8 sections of questions and answers submitted by the Monday we return by the Monday at midnight when we return. Questions? Questions on the exam? How many of you have taken the exam? I thought there was a bunch of you taking it. Okay. Well, there'll be an exam, and Danny Boy will be here for those of you that are taking it.